Hang on, don't overtalk me because that's going to show me what you're doing to them. Okay. Now it's just the time to listen. All right. And just do what you're told. There's not an excuse for what you did. That's not, you didn't just try to ask for some information. Okay. They wouldn't have sent this. They're very, very patient.
I just want to let you know I got a whole different view about it on the whole situation now too. I just got to meet my son for the first time on Friday. So
well, this is very unfortunate.
Yeah.
So you'll, but here's the thing. There's no reason for you to still not get this probation, but I don't have a choice now, but to get this pre-sentence report done. So I'm going to, hang on, I'm going to revoke your bond. In your case at this time, you're going to go with the bailiff. Probation is going to come to the jail. They're going to do this pre-sentence report. Probably not today.
Good morning. How you doing?
I'm okay. How are you?
Pretty good.
So you're Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh, you were here just last week or the week before.
Yes, ma'am.
And you pled guilty to an offense and you were told to go to the probation department and do a pre-sentence report.
Yes, ma'am.
And I've gotten a memo from them that has some unfortunate information in here about how you acted while you were there and visiting with them.
Yes, ma'am. I was over the phone when the lady was arguing and stuff. I just wanted the information on when I was supposed to meet the dude. That was it. And
That's not how this reads.
they
They were so frustrated with you that they said they will not do a pre-sentence report while you're on bond. So do you know what that means?
my bond had to be paid off.
No, that means I'm going to revoke your bond
Okay.
and you're going to go to jail.
Yeah.
And then they're going to come to the jail and do the pre-sentence report. And you're going to be respectful to them. Or I don't have to go along with this plea agreement.
Yes, ma'am.
So listen, it's time to get a whole different attitude about all of this. I understand. I remember now when you were here, you don't like the whole situation.
Do I get a new bond today?
I'm not giving you a bond because you couldn't act right while you were on bond, which shows me that you see where I'm.
Yeah,
the
can we just like revoke the deal and take it to trial? I can't afford to go to jail, please.
You're going to jail regardless. Why?
Yeah,
Because do you want me to read the memo?
the whole thing. Yeah, can we play the voice recordings of the phone call in here today too, if that's the case? Because if you're just gonna believe what she says, then I believe I have the right to fight on behalf of what I have to say, and we need to be able to play those phone recordings.
You're going to go do that. You're going to go do that pre-sentence report.
Phone recordings today.
And you're going to go and hopefully be respectful and hopefully get this probation and not ruin your life over this. This is very.
As long as you think I'll be in there.
It's a very temporary situation. Mr. Rojas can come back and talk to you. I'm revoking your bond at this time. I find it's in the best interest until sentencing that there not be a bond. You can go back.
This is a perfect example of something many people misunderstand about the criminal justice system. Once a defendant is released on bond, they're expected to prove they can follow rules, not just avoid new crimes. The judge isn't revoking the bond simply because of an argument. According to the probation department, the defendant's behavior became so disruptive that officers refused to complete a required pre-sentence report while he remained free. That's a major problem because judges rely on these reports when deciding sentencing options. The courtroom message couldn't be clearer. Your attitude outside the courtroom can directly influence what happens inside it. Do you think the judge made the right call by revoking the bond immediately, or should the defendant have been given another opportunity to explain himself?
Back with the bailiff.
Question.
Was he? Well, I don't know. Maybe. I mean, if he, maybe I'll have him just sit for a little bit. Let's just see.
Judge,
Mm-hmm.
since we have him here, well, let's go ahead and test him.
That's a great idea. Let's do that as well.
The problem, I know what they did get out of the PSI from what they could barely read was some marijuana and fentanyl use. So maybe, I don't know, it just seems.
That's a great, yeah. Thank you, Mr. Nichols.
Yes, sir.
We'll do that as well. And he's already here, so let's get that done. Okay. Hey, Mr. Rojas. Okay, I just want to make sure since I'm getting them tested, you're gonna, okay, thank you. All right, well, no more defense attorneys. Hey, Mr. Lane on Lisa Pratt.
Your Honor, she's present. I believe.
Let's get her. Good morning, you're Lisa Pratt.
Good morning.
And this is 24 DCCR 1460. Ms. Pratt's charged with theft of property with previous convictions. And what's the announcement?
Your Honor, I believe we have a deal worked out. I would respectfully ask the court, depending on what the court wants to do. Did you see her put, she has one more doctor's appointment. We can either plead today, and I would respectfully ask for sentencing without a PSI to be set, maybe 30 days, or we could reset it for a plea, but.
Oh, is the agreement for some kind of time?
12.
What I'd like to do while you're here is go ahead, we can do the plea
Yeah.
and I'll reset it without the pre-sentence report. And then we can set a sentencing date based around a typical time for a PSI is about 45 days. If that gives her time for that last appointment, we can do that.
Yes, sir.
Okay, I'll hold it while y'all take care of that paperwork.
Yes, sir.
So, Mr. Patterson, you tested positive for THC. There's no reason you should have tested positive if you had stopped using before when you were in court last time. So obviously you're not doing what you're supposed to be doing with the drug patch and staying clean. So you give me no choice at this time but to raise your bond in your case. Let's see, what does it say that name? Current is set at $7,000 and give me a second to look at this. I'm going to raise your bond in your case to $25,000. Condition of that bond obviously is going to be that you have a drug patch on, but you can't, it's not just a matter of going and getting a drug patch. It's getting it changed every 2 weeks and it's the drug patch being negative and you staying negative. So if you make that bond, obviously you cannot use anything that has any type of THC that would test positive, legal or not legal.
Sure.
And you have to have the drug patch on within 24 hours of your release.
Now the courtroom shifts to another defendant, but the underlying principle stays exactly the same: accountability. Drug testing while out on bond isn't just a routine formality. It's often a condition of remaining free before trial. A positive THC result, especially after being warned previously, tells the judge that court orders aren't being taken seriously. That's why we see the bond jump dramatically from $7,000 to $25,000. It's not simply about marijuana itself, it's about compliance. Throughout this docket, one pattern keeps repeating. Defendants who follow every condition often keep their freedom, while those who ignore even seemingly small requirements face immediate consequences. Which consequence surprised you more so far? The revoked bond over the probation incident or the massive bond increase after the failed drug test?
From custody. You can go back with the bailiff. Mr. Kelly, you have Davin Kalina or Davin Kalina?
With the court hold for just a moment, please.
Yes. What was that? I shouldn't do it anymore. It's all right, there's still time for that.
Should be time.
Yeah. It's no problem. I'll do that either way, whatever. Do y'all need me to?
I think we need to have just a short conference with the court.
Okay.
And then another matter, but we're at your permission.
Okay. Y'all need me in the back or y'all just need to come up off the way?
Maybe when we take a break there too. Just
Okay. See, Mr. Gertz, you've got Dan Church. Morning.
I'm Judge Harry.
Good. How about you? Good morning, sir. Are you Dan Church?
Yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And what is the announcement?
Judge, we're still working on this case. We've been here in one setting about a bond issue, which I think we've got sorted out. But
Right.
other than that, we're still working through the discovery. I think that was only a couple of weeks ago. We're still working through it. I'd ask for a normal resetting on this,
Any
so he and I
issues?
could discuss.
Sure.
I have no issues with that, Your Honor. I have an offer that I can tender to counsel at the appropriate time. I would like the record to reflect that since that bond hearing, I have asked Ms. Tanner, and she kindly sent me the transcript of that, just so we could all be on the same page with regard to that. There have been no issues brought to my attention, and so we can just keep everything as is. I think hopefully we'll be able to resolve this.
Perfect. Thank you. All right, we'll just do a normal reset. Mr. Church, make sure you stay in touch with Mr. Gertz so you can visit with him before that next court date.
Thank you.
You're free to go, sir.
Good.
And then you've got Toy Frazier. Can you hold that? It's on final reset. And then what about Jace Stovall?
He is present, Judge. Could we hold on that too?
Sure.
I need to talk to him about whether
Sure, I'll hold it.
we've got a new prosecutor on that. So.
Don't get excited. Don't get excited, get excited.
Reset that and just get with me and we'll get together and we'll pick a day for that one.
Yes.
And Mr. Clean is free to go. It's on my desk. I'll sign it. Yeah. See, Mr. Comerford? You don't look like Mr. Comerford.
Covering for Mr. Comerford.
Let's see. And is it Busick?
Yes.
Hi, Miss Busick. Come on up. And this is Simon Gobert. Good morning, Miss French.
Good morning. By the way, I forgot you were in trial last week. I wasn't in trial, so I wasn't thinking about that.
Good morning, sir. Are you Simon Gobert?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes.
Mr. Gobert, in cause number 24, DCCR 0512, you're charged with the second-degree felony offense of attempting to commit sexual performance by a child from August 2nd of 2023. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Busick?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $2,500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1. Any objection?
No objection.
It's admitted. Is there any evidence that Mr. Gobert is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right behind you. So stop and talk to her on your way out, and then we'll see you back at sentencing.
Yes, ma'am.
Nice to meet you. Thank you.
Thank you. You as well.
This hearing highlights an important distinction that many viewers overlook. Even after a defendant pleads guilty, sentencing doesn't always happen immediately. Instead, the judge orders a pre-sentence investigation, often called a PSI, to gather a fuller picture of the defendant's background, criminal history, employment, family circumstances, and overall suitability for probation or other sentencing options. That extra information helps the court make a more informed decision, instead of relying only on the facts of the offense. Notice how carefully the judge confirms that every right is understood before accepting the plea. Those questions aren't just routine. They're legal safeguards designed to ensure the plea is knowing, voluntary, and cannot easily be challenged later. Would you rather see judges take extra time gathering information before sentencing, or should punishment happen immediately after a guilty plea?
Mr. Lane, you have Lisa Pratt.
Ready, Your Honor.
To you. Being all aware.
Judge,
Yes,
he
sir.
ended up having to put Mr. Riley in the chair, the front chair, because he's banging his head and hurt himself. So he got him in the chair back there.
Okay, did he ever?
No.
Then don't worry about it. Y'all can just take him back. Let me put that on the record about Mr.
Riley. Corbin Riley.
That's right. Mr. Riley refused to submit to your analysis, had to be put in the chair because he was banging his head and being, trying to hurt himself. And so gonna go ahead and have him. And he did admit also,
Smoking marijuana last
to at least smoking marijuana last night, if not anything else. So we'll go forward that way. Okay. Mr. Smith? Is Mr. Smith here? Who's Mr. Smith today? On Lisa Pratt?
Excuse me, Mr.
Yes, sir. Thank you. Yes, correct. That's to do the, get the pre-sentence report done. Do you mind signing that, please? All right, ma'am, you're Lisa Pratt, and will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Pratt, in cause number, no, I have me pull the right one up. I'm sorry.
Move dams for the water.
Okay. And are we just going on count one with the, and
We are, Your Honor.
okay. Ms. Pratt, in cause number 24 DCCR 1460, the state's elected to proceed on count one only. It alleges that you committed the state jail felony offense of theft of property with previous convictions from April 1st of 2024. It further alleges that you were previously convicted of theft June 30th of 2023 in two different cases on that same date. And how do you plead to that charge? Speak up.
Guilty.
Are you, and are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes.
Do you fully understand them?
Do.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? And also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And the agreement that you've reached, it looks like is for a 12-month term in the state jail prison. And you guys have asked me to reset your case for sentencing for a short amount of time so that you can have a final appointment with regard to the issue on your leg or your knee. Is that correct? Or ankle? Ankle. I want to make sure you understand. In how long? When's the next appointment?
August the 20th or something, yeah.
Ma'am?
It's not till August.
Okay.
You said August 24th.
I might can get it moved out. I mean, I don't know how it falls. Today's the last.
All right. You're thinking. Okay. So I'm going to state tenders number 1.
No objection, Your Honor.
It's admitted any evidence that Ms. Pratt is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yeah.
Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing. I don't need a pre-sentence report. And I will reset it to the, August the 31st. It's a Monday. There's a few things that are very important about that. So if you are arrested for anything between now and that court date, I do not have to accept this plea agreement. Things could obviously be worse. Do you understand? Also, if you don't show up for that court date, obviously things could be much worse. I don't have to accept the plea agreement. You understand as well? All right, then, we will see you back at sentencing. You're free.
One thing that's becoming very clear throughout today's docket is that this judge is willing to show flexibility, but only when defendants demonstrate honesty and responsibility. Lisa Pratt wasn't sentenced immediately because of a legitimate medical issue, but the judge also made the consequences crystal clear. If she's arrested again or fails to appear at the next hearing, the negotiated plea agreement could disappear completely. That's an important reminder that plea deals aren't guaranteed until the court formally accepts them. A negotiated agreement can quickly fall apart if a defendant violates the court's trust before sentencing. As we move into the next cases, watch how consistently the judge balances accountability with second chances. Do you think courts should allow delays for personal hardships like medical treatment, or should every sentence move forward without exception?
Ready to go.
Thank you, Your Honor.
Mr. Kimler, you've got Evelyn Odom.
Fire department.
Thank you. Second, finish this. And we're going on a lesser, looks like.
Yes, just a straight evade.
Good morning, ma'am. Are you Evelyn Odom? And will your client waive the formal reading of the indictment?
So word.
Ms. Odom, in cause number 26 DCCR 0403, the state has elected to proceed on the lesser included offense of a Class A misdemeanor evading arrest or detention, and that is from February 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it's for 30 days in jail that would be sentenced today. Is that correct?
Well, she has a job. Explain to the judge.
Well, I mean, I just got a job. It's really hard for me to get a job, I guess, because I'm an age. And so I really would like to put in 2 week notices for CalCam. It's like just flagging a parking lot, it's $15 an hour. So I've been looking for a job for months. So if I put in a 2 week notice, then maybe they would hire me back. I mean, just because I haven't done that.
Okay, so we just need to reset for sentencing for 2 weeks. Okay.
You don't show up.
I'm coming out to here.
Well, I'll go through that with you just a second. So it's for a 30-day jail term, and are you a US citizen?
Yes.
State tenders number 1. It's admitted. Is there any evidence that Ms. Odom's not competent?
I'm aware of that.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for 2 weeks for sentencing. So that'll be on Monday, the 27th of July. And so you'll need to be in court that morning. We'll go forward with sentencing at that time, and then you'll go serve your time. It's very important, obviously, that you're here on that date. If you don't show up, I don't have to take this agreement. Things could be a whole lot worse. Also, if you are arrested for anything between now and when you come back, you run the risk of me not accepting the plea agreement.
Yes.
Do you understand?
Yes.
All right, then we'll see you back at sentencing in 2 weeks. What about Jose Lopez? Mr. Kimler?
Yes.
Good morning.
Good.
And would you please state your name for the record, ma'am?
Maria Morel.
Speak up, please.
Maria Morel.
Thank you, Ms. Morella. Would you please raise your right hand? You swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes.
Thank you. Sir, are you Jose Lopez?
¿Eres tú, José Luis? A ver.
Yeah.
Yes.
So
And Mr. Lopez's case is set for trial. To begin with jury selection next Monday. In cause number 25 DCCR 0211. Charged with solicitation of prostitution. And what is the announcement?
Your Honor, I would be ready, but I have the appointment by retina doctor in the Woodlands on the 22nd. It's taken me like 2.5 months to get the appointment. I haven't been there in like a year, so I need to go.
Did you file a motion for continuing?
No, it's set at 2:00. I just checked my calendar this morning on that. I mean, I can file one. I could pick a jury, but I would be unavailable Tuesday to try the case. I could come back and try it Wednesday.
Okay. Ms. French,
State's ready, Your Honor.
okay. And so your appointment is on the 21st?
22nd at 2:00.
The 22nd is Wednesday.
I think it's
Wednesday.
the 22nd. It's the 22nd. It's not the 20th, it's the 22nd. Saturday, Wednesday. I was thinking it was Tuesday. Okay. At 2:00. I know that. What did I tell you? Yeah, I told you. I'll be the drive. She's gonna drive me. I guess. I'll let your eyes. You can't see when you.
So I guess if we needed to, we could pick a jury Monday afternoon. We could work Tuesday afternoon, possibly even part of Wednesday morning, a couple hours, maybe
Yes, I'm on the road about 11.
11. And then we have all day Thursday. So we still, I would think on this type of case, have plenty of time.
Yes, Your Honor.
Okay. And it looks like the rejection before was for a 3-year deferred probation. Mr. Lopez, I want to make sure if we go forward with trial next week, that I will not accept any plea agreements after today. Do you understand?
Yes.
And do you still want to reject that offer for probation and go forward with a jury trial?
He wants a trial.
Okay. All right, then I will number the case tomorrow after docket. If we do go to trial, will you have your own, you'll have your own interpreter for him?
She translated.
Okay. Okay. All right. We'll see y'all next week. Stay in touch.
Here's one of the biggest decisions a defendant can make in any criminal case: rejecting a plea offer and taking the case to trial. The judge makes it absolutely clear that once today's hearing ends, the previous offer of deferred probation may no longer be available. That's because plea negotiations are exactly that, negotiations. Prosecutors are not required to keep an offer on the table forever, especially once the court begins preparing for trial. Going before a jury can be the right choice if someone believes they're innocent or the evidence is weak, but it also carries significant risks if they're ultimately convicted. This isn't just about confidence, it's about weighing certainty against uncertainty. Every defendant has the constitutional right to a trial, but exercising that right often means walking away from a potentially more favorable outcome. If you were in Mr. Lopez's position, would you gamble on a jury trial or accept probation while it was still available?
Touch with Mr. Kimler. He'll let you know what time to be back or what order the trials are for Monday. All right, you're free to go. Thank you. Okay. Oh,
I'll just give them and come back or he's not going to very expensive trial, so we can do his vision. You got no trial on it. Okay.
I'm using my chin as a table. Okay.
Mr. Kimler, you've got a sentencing on Ibriana Bell. Good morning. Are you Ibriana Bell?
Yes, Laura.
And Ms. Bell was previously in court, entered a plea of guilty to theft of property with previous convictions. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir, we have.
Any additions or corrections?
No, from the front. No, Your Honor.
All right, Ms. Bell, how old are you?
25.
You're 25 and you're already adding up some history that started as a juvenile. I'm going to go along with this agreement. And I really, really hope that you use this as an opportunity to do better for yourself and to break the cycle of what's been going on with you and your family. Looks like from what I can tell, everybody in your family's been to prison or in trouble. And so you can at some point continue doing all of that stuff and end up like that, or you can say, I'm going to do something different with my life. And that's going to be up to you at this point at your age, right?
Yes, ma'am.
It's not fair that things happen the way they did, but you're an adult. And so you can make those decisions for yourself at this point, right?
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, follow the agreement that you made and find you guilty of theft of property with previous convictions. Sentence you to a term in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 3 years. You're ordered to pay the $500 fine as well as the $221 in restitution. And actually what I'm going to do today is I'm going to reduce that fine to $250. I want you to succeed. And I don't want the money to be the issue. I want that restitution paid off first.
Yes, ma'am.
Okay. I want you to get a job and I want you to pay that off as quickly as you can and then do everything else that you're supposed to on probation. If you do everything you're supposed to, then for all practical purposes, your case here in court's over and you'll be able to serve that 2-year sentence while you're out on probation.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you'll be brought back into court, your probation revoked, and you'll be facing that 2-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Kimler. So if you'll just have a seat here in the courtroom, probation's going to call you up to her desk to go over your paperwork. Okay, good luck to you.
Thank you, Your Honor.
You've got, did I just hear you?
This may have been the most powerful moment of today's docket because the judge wasn't simply handing down a sentence, she was trying to change the direction of someone's life. Notice that although the defendant received a 2-year state jail sentence, that punishment was suspended in favor of probation. That's a tremendous opportunity, but it's also a warning. Probation isn't freedom without rules, it's a second chance with strict conditions attached. The judge even reduced the financial fine so restitution to the victim could become the top priority, showing that accountability isn't always about imposing the harshest punishment possible. Instead, it's about creating the best chance for rehabilitation while still protecting the public and ensuring victims are compensated. At the same time, the judge made one thing unmistakably clear: violate probation, and that suspended prison sentence can become very real. Moments like this remind us that courts aren't only deciding punishment, they're deciding whether someone deserves one more chance to rebuild their future. Do you think probation was the right decision here, or should repeat offenders face immediate jail time instead?
Okay, I'll do that in just a second. What about Angel Mata Rodriguez, Mr. Kimler?
This is a probation matter now.
This is Mr. Smith's on Angel Mata Rodriguez. Good morning, sir. Are you Angel Mata
Yeah.
Rodriguez? And this is 23 DCCR 1106. Mr. Rodriguez is on Probation for evading arrest or detention with use of vehicle. Motion to revoke has been filed. What is the announcement?
I anticipate being able to discuss it with Mr. Smith this morning, Your Honor. I don't know that we have to have a hearing. I think he's picked up a new case. Is that right? I honestly, I don't know. Your Honor, Mr. Smith is around. He's dealing with crisis from over the weekend. He is here if we need him, but I've got his file and there's an
Why don't I hold it?
yeah.
Y'all can just
I
take a
won't
look at
speak
it.
out to him.
Yeah.
All right.
And if he needs to run down or if y'all need a reset, just let me know, but I'll hold it for now.
This is not his.
I just realized that.
And then Jorge Del Fiero.
Wait. Chance.
Discovery. Okay. Good morning, sir. Are you Jorge Del Fiero? And will your client waive the formal reading of the indictment?
Sure.
Mr. Del Fiero, in cause number 25 DCCR 0892, you're charged with the third-degree felony offense of assault family violence by impeding breath or circulation from January 31st of 2025. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to participate in AA as well as anger management, have no contact with the victim,
I put direct contact.
direct contact. You would be able to use the Family Wizard app or program to communicate with regard to your children. Do you understand? Okay. And do y'all use that already?
No, I go straight to mom, but I'm even having issues just to see my son.
Yeah. So it's a great, here's the thing, that is a great tool. It protects you and her both because it takes everything that it has a calendar. If there's a doctor's appointment, if there's a soccer game, whatever it is, if you need to find out information, you can both input information. It's like an email program, but everything's saved. So everything
Yes.
you say saved, everything she say saved. She can't say you said something you didn't, so, and vice versa. So
And what if she's trying to get in contact with me or like just without using the app? What do I do about that?
hang up and say, if she texts you, say, use Family Wizard. And that way, and keep that, forward it to your attorney so that if she comes back and says, oh, he contacted me, you can have whatever you need to protect yourself.
Yes.
Okay, I don't even
And
know.
also, I know she worked. Her mom sells drugs and all this. She be having my son stay.
Objection.
So, here's the thing. If there's issues, you need to go through family court. All right, you need to talk to Mr. Kimler, get a lawyer, get all that worked out another way. I don't have any say-so over any of that. All I have is say-so over you. Okay, so if you want to stay out of prison on this probation, you got to follow these rules. And if you need to go take care of some other things so that y'all have rules to live by down in family court, then you need to get that taken care of as quickly as possible.
Yes.
Okay, so it looks like also,
Can I help you out, Your Honor?
yes, please.
Defendant will pay 100% of the cost for 5 years for the Our Family Wizard program, and also agreed for probation to do an assessment to help him with any needs they may be able to help him with, refer him to.
So pay 100% for both of them?
He's paying the total cost for 5 years.
Okay, and that's y'all's agreement?
Yes, Your Honor.
Okay, that's good because it helps everybody. All right, do you understand that all of that is the agreement? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Mr. Del Fiero is not competent? All All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing.
Yes.
You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there.
Yes.
All right, we'll see you back at sentencing. Thank you. Thank you, Ms. Branch.
One of the most interesting parts of this hearing isn't the guilty plea, it's the judge's focus on preventing future conflict instead of simply punishing past behavior. In family violence cases involving children, communication between parents can quickly become another source of legal trouble. That's why the court requires the use of the Our Family Wizard app. Every message, calendar update, and request is documented, creating a transparent record that protects both parents from future accusations. The judge also reminds the defendant that family court, not criminal court, is the proper place to resolve custody and visitation disputes. That's an important legal distinction many people misunderstand. Criminal courts enforce criminal laws, while family courts decide parenting rights and child-related issues. By explaining the purpose behind these conditions instead of simply reading them aloud, the judge is trying to give the defendant the tools to successfully complete probation and avoid coming back into court. It's a reminder that following probation isn't just about obeying rules, it's about making smarter decisions in everyday life. What do you think? Should courts require communication apps like this in more high-conflict custody cases?
I'm sorry, what?
Not to leave just yet. I feel this friend.
Yeah, they may not have gone through, so don't tell them not to leave yet, just in case. Please, ma'am. Thank you.
Just to let the court know, I do have Trooper Lucio here for that hearing on all the elements. I'll just call Ms. Kane on probation whenever you're ready, but it will be very.
For the 11 o'clock hearing?
Yes.
Okay, yeah, if we get done beforehand, I'll definitely start that early. Thank you.
Wait to see if it.
Oh,
We're just having a short.
no.
See, is Mr. Morgan, good morning, Mr. Morgan. I'm William Nesbitt.
Yes, sir.
Right, the new office. Give me that.
My name's Matt
Good morning.
Novak. I work for Morgan.
Oh, I'm sorry, what's your name?
Matt Novak.
Govak?
Novak.
Novak.
Yes.
Novak. Good morning, Mr. Novak.
Morning, Judge.
And sir, are you William Nesbitt?
Yes, ma'am.
And this is cause number 23 DCCR 2098. Mr. Nesbitt's charged with aggravated promotion of prostitution from February 5th of 2023. And what is the announcement?
At this time, we are not ready. And I talked with the state. There's a newly assigned case. So we're fine with giving the state a chance to review everything and then go from there in terms of doing a plea negotiations position.
And the reason, Your Honor, I noticed there was an offer made back in June of 24. Of course, that was before the arrest and incarceration in Harris County. The reason that Mr. Nesbitt's bond had been revoked and increased.
Okay.
And so I need an opportunity to review what's taken place
Sure.
with TDC and make a new offer, because obviously the 5-year TDCJ is off the table after that.
Okay, so let's do this. I'll just do a normal reset, about 30 days, give Ms. French some time to get caught up. She'll send you guys over, I'm sure, whatever information she has in an offer. Make sure you stay in touch with your attorneys so that once they get that information from Ms. French, we can get an announcement at that next court date.
Yes, ma'am.
All right, we're free to go. Thank you.
Thank you.
Mr. Nix, you've got Alexandria De Leon.
Yes, sir.
Good morning.
Good morning, Judge. How are you?
Good. Good morning, ma'am. Are you Alexandria De Leon? This is 26 DCCR 0143. Ms. De Leon is charged with assault on a peace officer. And what is the announcement?
Your Honor, we need one more reset. We have something verbally worked out. We're getting a few letters of recommendation to turn over to the state as part of the plea agreement. And also I'm waiting on a letter from Mr. Green that should be taken care of next month.
All right, so we'll just do a normal reset and Ms. De Leon, make sure you stay in touch with it. It looks like you were just hired in May,
Correct,
correct?
Judge.
Yep, so we'll just do a normal reset, give you some time to get all that taken care of, and we'll see if we can get an announcement the next court date.
Thank you, Judge.
Thank you.
You look bad too. That's not look. I didn't. You didn't call. People get rid of those, but I had it.
Mr. Nichols, were you lost?
Hey, I'm just trying it out.
I look over and I'm ready to call. I'm like, oh, we have somebody over here ready to go, but
It feels weird.
I bet it does.
Been a long time since I've said
Let's
it.
see, Mr. Gertz is,
I'll-
Mr. Kimler, you're working on one still.
Awesome.
And Mr. Galmore came and so I've got Galmore, Gertz, Kimler on this docket.
Thank you. I'll print discovery.
Man. You're funny.
Well, it's reputation. Probably. And so
Looks like sanction or something.
you can ask for one, but he's more likely to get one that admits that he was smoking instead of saying, no, I didn't do it. Excessive positive.
Kimler, Miss Malfino, while we're waiting a few minutes, I want to get Mr. Ellis tested this morning. Malik Ellis. We'll get Malik Ellis, please.
Malik.
Good morning. Good morning, ma'am. You're Cynthia Williams. And Miss Williams, this is your initial appearance in cause number 26, DCCR 1106. You are charged with aggravated assault with a deadly weapon from May 17th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Miss Williams, is reset your case about 30 days to give you some time to try to hire someone.
I need a court approval.
Well, so once you've made a bond in your case, I expect you to at least try to hire an attorney. And then, are you working?
No,
Why not?
I'm disabled.
Do you get disability?
Yes, ma'am.
How much do you get a month?
1,000, but my rent is 1,000 something.
Now, what is your actual check?
I get 2 checks. I get my husband, because he died. I get his, I get mine too.
Okay.
So
What's the total?
I think like 1,200.
How do you not know what the total is that you get every month?
Because his is eight something and mine is 670.
Okay. All right. I'm going to have you fill out some paperwork this morning. Miss Williams, you need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct about your income and your expenses. And then I'll take a look at it to see if you qualify.
Yes.
Step in front of the clerk.
She wanted to go in. What we do is exception, if it doesn't sign making addition, don't receive it much, the sign the back, not to do the native, nothing doesn't, don't leave and don't come back and get finished. Thank you.
Thelma Garza. Thelma Garza.
No response, ma'am.
Bond will be forfeited for non-appearance and reset at 100,000. Deborah Elliott. Good morning, ma'am. Are you Deborah Elliott?
Yes, ma'am.
And Miss Elliott, this is your initial appearance in cause number 26 DCCR 0618. You're charged with the 3rd-degree felony offense of financial abuse of an elderly individual from October 21st of 2025. Since you've made bond in your case, if you had an opportunity to try to hire a lawyer?
No.
All right. So what I'm going to do, Miss Elliott, is reset your case for about 30 days to give you some time to try to hire someone. Well, same thing I just said. If you bond out, then I expect you to try to hire your own lawyer. Are you working?
Yeah.
Why not?
I just get part value.
Do you receive disability?
No.
Then how do you pay your bills?
My son pays.
Okay. Is that how you got out of jail?
My sister.
Check something.
Yeah.
And just give me a second to look at something. So what I'm gonna do is have you fill out some paperwork, Miss Elliott, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately, and completely, because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. You need to step in front of the clerk on the end and she'll give you that paperwork. Christopher Henry. Christopher Henry. I didn't either at all. Yeah, here we go.
He's Brother John. Get your hands out of your pocket. Come on, right here.
Good morning. Are you Christopher Lee Henry?
Yes, ma'am.
And Mr. Henry, this is your initial appearance in cause number 26 DCCR 1070. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from April 3rd of 2026. Since you've made bond in your case, if you had an opportunity to try to hire a lawyer. Right. So what I'm going to do, Mr. Henry, since you've made bond, is I'm going to reset your case for about 30 days to give you some time to try to hire a lawyer. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and we'll discuss your options.
Right.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you'll go back to jail. Do you understand? All right, step in front of the clerk. She'll give you a reset notice. Show them.
Yes. Oh, yeah. All the
Lakeisha Petrie. Good morning, ma'am. Are you Lakeisha Petrie?
Yes, ma'am.
And Ms. Petrie, this is your initial appearance in cause number 26 DCCR 1032. You're charged with a state jail felony offense of credit or debit card abuse from March 7th of 2026. And since you've made bond in your case, if you had an opportunity to try to hire a lawyer. So I'm gonna, same thing you've heard me saying, I'm gonna reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you your reset. Good morning, sir. You're Jerry Dickert.
Yes, ma'am.
And Mr. Dickert, did you get a lawyer hired?
I haven't hired one. I've talked to 3. I don't know if you received my email. I don't have a vehicle. Had one repossessed and one stolen.
Who'd you talk to? What lawyers?
To there are 3 Houston firms, a Martinez law firm that gave me their payment plans and the estimated cost based on my cases. Huff Law Firm in Houston and Dunbar and Jones. And I've also looked into something called case funders that will allow me to borrow the money to pay for an attorney.
Do you, thank you for doing what I asked you to do. Do you want to fill out the paperwork this morning to see if you qualify for a court appointed lawyer? Or do you want to see if you get that money and hire your own with one more reset?
I'm living on unemployment right now, which is about $1,000 every 2 weeks. But I mean, there's,
It's okay. I just need to know if you want to fill out the paperwork this
Yes.
morning or if you want to get 30 more days to try to hire someone.
if I could have 30 more days, I would appreciate that because I think I can get a vehicle and get a job.
I'll reset you one more time and then if you make sure you talk to some other attorneys, bring back any information you have with regard to if you've gotten a job, and then we'll see what your options are if you don't have someone. Step in front of the clerk, please.
Thank you very much.
Yes, sir. Varenus McIntosh. Good morning, sir. Is it McIntosh or Tosh? McIntosh, you're Vernus McIntosh. Mr. McIntosh, this is your initial appearance in cause number 26 DCCR 1090. You're charged with the third-degree felony offense of failure to comply with sex offender registration requirements from May 20th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I called one of Elaine Walker. He wrote $10,000 and I'm gonna be looking for somebody else.
So what I'll do then, Mr. McIntosh, is reset your case about 30 days or so to give you some time to see if you can get someone hired. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
And can I ask you a question?
What's that?
I know I've been registered since 18 and I know it's a lifetime. Is there any steps that I can go through that I was looking up online that I can possibly get
You're
off
gonna
the
have to talk,
registration?
you're gonna have to talk to a lawyer about that. So let's get through the case first and the lawyer you get, also talk to them about that. There may be some options for that, but that's not something that I'm not allowed to give legal advice.
Okay.
So if you get someone hired, again, bring that reset notice to them. If for some reason you don't get someone hired, make sure you talk to at least 3. Bring me back those names so I know who you've talked to and we'll discuss your options.
Yes.
Okay, step in front of the clerk. She'll give you a reset notice.
It's not just enough chatted here.
Hold on just a second, please. Did I, was this one arrested again and then bonded out? Or did I just reset it that day? Because it says condition of bond was drug patch within 24 hours. Right. So I didn't arrest him that day. I didn't put a warrant that day. That's okay. So we should definitely have at least one back by now, and we don't. Travion Patterson. Good morning. Are you Travion Patterson? And Mr. Patterson, you were here before and I tested you and you tested positive. And I told you to get a drug patch. Did you get a drug patch?
Yes.
Have you had it tested?
No.
Have a seat in the jury box and we're going to get you tested this morning. Then we'll. Hey, Mr. Nichols, did y'all want to?
Yes, sir. Please call Ms. Deshawn Robertson.
I'm sorry.
Ms. Deshawn Robertson. She's right outside.
Deshawn Robertson, cause number 25 DCCR 0914.
That's correct, John.
Good morning, Your Honor.
Good morning.
Mr. Naismith had filed
Second. Good morning, ma'am. You are Deshawn Robertson,
Yes, ma'am.
and Ms. Robertson is charged with aggravated assault with a deadly weapon, and there is a motion to modify or delete a bond condition that was filed with regard to
It's,
not driving a car.
correct, Your Honor. And Your Honor, we've discussed it. I've looked at it. I don't have any opposition to letting her drive for those limited reasons that were requested.
These are regular NHMR appointments, Your Honor. These are any doctor appointments for her youngest child who's still in school. Her youngest child goes to school in Nederland, Texas, away from here in North Beaumont, where she currently lives. And she's also on GPS and employed, Your Honor. GPS is current as well.
The reason the driving was added at the beginning, Judge, was the assault involves hitting someone with a car.
Okay. That's good.
It wasn't an intoxication situation. Your Honor.
Okay. So you are working or you're not working?
Yes, ma'am, I'm working.
Where do you work?
I work at Rose's. I'm a customer service manager.
At Rose's?
Yes, ma'am.
Where's that?
On Concord in Beaumont.
And where do you live?
On Thames Street in Beaumont.
THAMES?
Yes, ma'am.
That's just the order setting a hearing. Oh. And your child goes to school where?
At Evolution Academy.
Right, Mr. Nichols, you have no objection?
I don't, Your Honor. I reviewed his motion. We discussed it over the last few days, and I don't have an opposition to lifting those conditions.
The NHMR is at the Spindletop location as well, Your Honor.
Right.
Sorry, my apologies.
Yep,
I keep forgetting.
and that's in Beaumont.
Correct.
Oh.
Yeah, let's go. Spindletop.
Okay, so here's what I'm gonna do. I'll grant the motion to modify the condition. I am going to allow you to drive. It's still gonna be for limited purposes though. So it's gonna be go to work, take kids to school, and go to any medical appointments, either doctor or medical through Spindletop, right?
Yes, ma'am.
That's it.
Yes, ma'am.
Other than that, you need to be at home.
Yes, ma'am.
Okay, and not driving around town and obviously not having any contact at all with the complaining witness that we've already talked about.
Right.
Okay,
Yes, ma'am.
anything else?
Nothing.
Okay,
Not this point, Judge.
okay. All right, then I'll just reset your case for an announcement, give you some time to get all of the evidence. Make sure you visit with your attorney before all the discovery. Make sure you discuss all of that with them before that next court date, see what the announcement is.
Thank you, Your
All
Honor.
right, you're free to go. It's okay. Well, it was the title. That's funny. Yes, ma'am.
Standing for Mr. Galmore and Justin.
Are you ready on Orlando Vergara?
Mr. Galmore is actually on his way in. He's gonna make that announcement.
Okay, thank you. Deborah Elliott. Did they have the attachment?
The attachment. So, but not.
It's not. Justin Zaruk, Miss Simon. Morning. Good morning. Good morning, sir. You're Justin, is it Zaruk?
Zarek.
Zarek, and this is cause number 26 DCCR 0317. Mr. Zarek's charged with driving while intoxicated with a child passenger. And what is the announcement?
Yes, Your Honor, we've received the offer in this case. We're just asking for additional time to.
I have no issues, Your Honor. I've given 2 alternative offers, and that may allow some time for them to get some mitigation documents for me.
All right, thank you. So we'll just do a normal reset. It's about 30 days or so. Make sure you stay in touch with your attorneys. They'll let you know when you need to be back. You can visit with them between now and then about all of the discovery in your case, and we'll see if we can get an announcement.
It looks like the media has been tendered.
Okay, thank you, Ms. Malvino. Okay, thank you. All are free to go.
Yes. Not far from that. I emailed the ombudsman back.
Okay.
It's wrong attachment, but technically it's for.
Oh, wrong person. Gotcha.
Wait, because I you got you know, it's on you should be with me before you can have on the school. Okay. You're bringing it. I'm sure, like, you didn't know the schools.
Next week's public.
Yes.
Maybe tomorrow. Yeah, there's something.
That's what I was just looking at.
Today's courtroom session showcased exactly why every hearing matters, whether it's a bond review, a guilty plea, a sentencing, or simply requesting more time before trial. Throughout this docket, one lesson stood out above all others. The courtroom rewards accountability and honesty, but it responds quickly when defendants ignore court orders or violate the conditions they've agreed to follow. We saw a defendant lose his bond after creating problems with probation, another face a dramatically increased bond after failing a drug test, several defendants receive opportunities through deferred sentencing and probation, and others make life-changing decisions about whether to accept plea agreements or risk taking their cases before a jury. We also watched the judge balance firmness with compassion, explaining legal procedures, encouraging rehabilitation, and reminding defendants that every decision they make outside the courtroom can shape what happens inside it. That's what makes these proceedings so compelling. They're not just about punishment, they're about responsibility, second chances, and the real-world consequences of every choice. If you found this courtroom breakdown informative, Let us know your biggest takeaway in the comments below. Which ruling do you think had the greatest impact, and would you have made the same decisions if you were in the defendant's position? Don't forget to hit the like button, share this video with fellow courtroom enthusiasts, and subscribe to the channel for more real courtroom breakdowns, legal analysis, and the most unforgettable moments from inside America's courts. We'll see you in the next case.